generally, so I'll try to kind of run through. I want to make sure that we have plenty of time for everybody's questions, but just kind of doing a general overview. The number one distinction, or the first place you want to start generally when you're dealing with student loans is it a private loan or is it federally subsidized loan? And that's the first question I always ask to people when they come to me, and I almost always get an answer, oh, well, I know for a fact it's private or it's federal because I have it with Sally Mae or so on. But that's not really a definitive benchmark of whether it's federal or private. Really the best way to figure out if it's federal or private is you have to look at your original loan application or your original promissory note, because how it works is a federally subsidized loan is one where if you default, it's going to be paid off by either a state guarantee agency or the Department of Education. It's going to be backed by the government. And there's been a lot of changes in this program, and so that's why it's kind of, there's not one set way to identify everything, because there are lots of times when you're dealing with student loans, these may have been, people contact me about student loans that were taken out in 2004, or the very next day somebody would call me about one that was taken out in 1982. So it's changed a lot in that time period, and there's lots of different parties involved in that. But generally you want to look at the original paperwork of your application and what was signed. And if you don't have a copy of that, which most people don't, you do have the right to call it. If somebody's trying to collect from you, you have the right to ask for a copy of a validation of the debt, and whether, send me some sort of proof that I owe this money to you. And that's not just with student loans, basically with anything you're dealing with, that's always a good first step. If somebody's trying to get money from you, is request validation of it. But there are several different types of federal loans. And like I said, they've kind of changed over the years, but there was the Family First Educational Loan Program, which FFELP, which is a very common one. There's Perkins loans, Stafford loans, and more common now are the direct loans, which are directly made from the Department of Education. And that's something that changed. But I'll get into that more in a little bit, because it can be very confusing about trying to figure out who all the parties are. You either have a loan that was taken out with the promise that some sort of governmental agency was going to back this up and be the guarantor if you defaulted on it, or you have what's called a private student loan. Private student loans became much more common within the late 90s and 2000s, just like every other type of consumer debt with mortgages and car loans, whatever. It essentially works the same way as the mortgage market and all those other types of consumer debt, is that people would originate these loans and then just sell them immediately to someone else, and it's like a hot potato, so nobody was actually on the hook for these loans that they were making, so it ended up, just kind of whoever would write loans, lots of people have gone bankrupt or gone out of business, and it changed hands 100 times, so it can be difficult. But if you're dealing with a private loan, just for instance, let's say hypothetically Main Street Bank or something like that, you would have gone to the bank, and underneath the original loan application and the promissory note terms, there's not going to be anything in there about the Department of Education or guarantor or anything like that. You want to look strictly at that application you filled out, and generally there's going to be some sort of language in there if you can read it. Now, most of the time when you say, can you please send me the note or the application to verify this debt, you'll get some sort of fax document that is, says loan application on the top, and that's about the only thing that's legible on it, because it's a 6th generation copy or something like that. But if you can get your hands on a legible copy of what you actually signed when you took out the loan, there should be some language in there that will guide you as to whether this is backed up by a state guarantee agency or the Department of Education. And the reason differentiating between those two is where you want to start out, because your rights and their rights as creditors are not vastly, but they're pretty different whether it's a federal loan or a private loan. I'll just kind of go through the private loan first, because that's kind of an easier easier one to go through. But for instance, you took out a loan with Main Street Bank. And lots of times, private loans will require a cosigner. So if you have a parental cosigner, that's not a guarantee that it's a private loan, but it's highly likely that if there is a cosigner that was required on your loan, that was a private loan. Because that's far more common in the private student loan market. So for instance, if you took out a loan with Main Street Bank and then they asked you to get your mom or dad to co-sign on it, that's a good indication that that's a private loan, and you're both going to be on the hook for that loan in a private loan, because, and one of the reasons it's more common to get those co-signers is because if they don't have the guarantee of, if you default, being able to go to the government and get payment, they want to be able to go after somebody else. And so they're essentially looking for a private guarantor to fill in that role that the Department of Education or state guarantor agency fills. So if you took out a private loan, you probably filled out an application with Main Street Bank, and then by the time you graduated or left school, you started getting notices from someone else about where to mail in your paycheck. Or not, well, Freudian slip there. Where to mail in your monthly payments. But you have the promissory note, and legally speaking, this kind of operates the same as like all consumer debt issues. If you have a promissory note, that is your written contract. That's like if I borrowed 20 bucks from you and wrote you an IOU. It's perfectly legal to sell the rights in that piece of paper to other parties, and it gets transferred throughout multiple parties, usually up on Wall Street. A bank will issue a student loan note, and then they'll turn around and sell a portfolio of them immediately to this party, and they'll sell it eventually. And so you keep getting these notices over the years of, well, your bank with Main Street is now with ABC Bank, is now with XYZ Bank, so on and so on. And the person who's legally entitled to collect from you is the person who is the legal holder of that note. However, the legal holder of your note is not necessarily going to be the person you're sending your monthly payment to, or the person asking you to send your monthly payment to. Generally, if you're dealing with somebody like Sallie Mae or Citibank or Discover, these are not people who probably actually hold the legal right to your promissory note. They're going to be servicers, which is similar to if you have a mortgage, you're paying your monthly payment. You're not actually paying your monthly payment to the person who holds your deed or promissory note. So the servicer is going to be someone like Discover or Sallie Mae, who takes your monthly payment of, say, $100, and they're going to keep 5 cents of that $100 and mail the $99.95 up to the person who actually owns the note. And usually that's some sort of big bank up on Wall Street who owns tens of thousands of notes in a portfolio, and it gets all complicated into high finance, and we won't go into that here. So your servicer is going to be the person who is receiving your monthly payment and sending you the notices and things like that. It's important to identify the parties here between who actually has the right to collect from you. Because oftentimes once you go into default, you'll get a letter from Sallie Mae or Discover or whoever as your servicer saying you're late on this payment, please make arrangements to pay. But then they will send it to another party, a collection agency, who's hired on behalf of the promissory note holder, who starts calling you and saying, harassing you and calling your phone 5-6 times a day, things like that. They're also a third party who doesn't necessarily have the rights to enforce your promissory note. The only person who can take legal action against you on a private student loan is the person who is the legal holder of that promissory note that you signed when you took out the loan. So I'm kind of a visual person, so I'm just kind of, and I feel I have really horrible handwriting, so I get a little bit self-conscious drawing my graphs, but I'll try to kind of set it up here. So here is our borrower who takes off the original loan right here from the bank. and you sign the promissory note and it goes to them. Almost immediately, they sell it up here to another party. Let's call them ABC Bank or whatever. Your monthly payments that you're making are going to be to a servicer. Let's put S for servicer right here. So you may make your monthly payments here for 4 or 5 years to the same servicer, but your actual promissory note may have changed hands 3, 4, 5 times, maybe more, over that 5-year period. But every month, you're making your payment right here to your servicer, and they're either sending it here or there, depending on who owns it. Now, when you go into default, whoever owns it out here, they're going to hire another company, a debt collection agency, who's going to start calling you. We'll just go right here. Told y'all I had bad head.
You could have put a less generous name on there, Chris.
Oh, what?
You could have put a less friendly or generous name on there.
So after you default, you start getting these phone calls. People blowing up your phone at all hours, which, by the way, you have rights about when they can contact you. You get in a situation where people are calling you at work, or calling you after certain hours at night, or calling you, or calling your parents or things like this, if they're not on the loan, or third parties, then they may be violating your rights under the Fair Debt Collection Practices Act, which is a federal law that protects kind of what actions debt collectors can take against you. And they get violated a lot more than you would think. The debt collection agency is going to call you up and say, hey, you're behind. Can you, and this, once again, this is all private loan right here. And say, hey, can you make a payment, just pay $10, this and that, so on and so on. They are paid off a commission of whatever they collect from you. They get a percentage of whatever they get. The power of a debt collection agency is strictly psychological. They don't have any legal rights that they can take against you. They can't take you to court or anything like that. Now, when the promissory note holder goes over and hires a collection law firm, then you're in a more serious situation. But when you're just being called and sent letters by collection agencies, and you'll know it's a law firm when you get the letters, because it'll have their letterhead and stuff like that, or they'll identify themselves in their phone calls. But when it's strictly a collection agency, the only power they have is psychological. They don't have any legal right because they are not the promissory note holder, and they're not attorneys, so they can't take you to court. The only thing they can do is get you to voluntarily give them your money. That's the only power they have right now. And they'll tell you they're going to throw you in jail, they'll tell you this and that. Again, those are violations of the Federal Fair Debt Collection Practices Act. They don't really have those rights. And if they are telling you that, then you should probably contact an attorney or go see Michael down at Atlanta Volunteer Lawyers Foundation. He can put you in contact with attorneys who can help you. Now, once these people, and this will change hands generally once you quit making your payments. You'll get a call from one collection agency, they'll try to collect for a little while. Then you get a call from another one, they'll try to collect for a little while. So on, so on. That's why it can be really maddening once you go into default on student loans or any other type of debt, really, is you start getting phone calls from all these different people, and you just want to track down, say, okay, well, who did I take out this loan with? How do I get a copy of my original application, my original promissory note? How can I get my records about what payments I did make and how much interest y'all are charging? It can be, maddening to try to sit down and figure out who's who through all this. But collection agencies, you have the right to send them a letter and say, I don't want to be contacted, or you can have an attorney send one that says you're represented and they're no longer allowed to contact you. You don't have to talk to them, you don't have to return their phone calls, you don't have to do anything with collection agencies. Collection agencies are just little flies in your ear. You don't have to do anything. They have no power. They have no legal power to do anything against you. Private student loan after you default. Eventually, if you just stop making payments or never make payments, you're going to get to the point where a law firm contacts you. Generally, they will send you a letter first, trying to collect payment. And then, usually 30 days or however long after that, it's going to be at least 30 days generally, they might file a lawsuit against you. If you get served with a lawsuit, the worst thing you can do is ignore it. As soon as you get served with it, there are multiple organizations throughout the Atlanta area that can help you deal with when you're being pursued by collection agents or collection law firms on issues like student loans. Atlanta Volunteer Lawyers Foundation has a Saturday Lawyer program, excellent program, and one of the things they deal with is debt collection defense. So even if you're a person who can't afford an attorney or you're unemployed, there are programs out there to help you deal with these things if you get served with a lawsuit on student loan debt. So always make sure you answer that. Now, a private student loan, you're going to be dealing with the legal process like that, just like if you had defaulted on a car loan or a credit card or something like that. They'll serve you with a lawsuit, depending on the amount of it, depending on which court you're in. You'll have so many days to answer, and then you'll probably go through various stages before you eventually end up arguing in front of a judge if you hire an attorney. But they have to get a judgment against you. At this point, they still haven't taken any of your money. They have to win the lawsuit or get you to voluntarily agree to enter a consent judgment with them, or a payment plan, something like that. And they have to get a judgment against you. And again, a judgment is just a piece of paper. You can't do anything until they actually go and try to garnish your paycheck, or put a lien on your car, or put a lien on your house, or something like that. But you want to participate in the lawsuit because you have your most leverage in the pending lawsuit about negotiating the payment plan, or striking out some of the collection fees or things like that. That's why you always want to answer your lawsuit if you're being served by something like that. But once they get the judgment, then they have to go through a separate process where then they go and serve your bank or serve your employer with a garnishment notice, and then you'll start getting 15% or something like that, taken up to 25% of your take-home taken out of your paycheck. And that's the situation that you want to try to avoid, because at that point, you're not really having any control over your payments. It's just being taken from you. You just go to your bank account. You're required to get a notice if the garnishment is coming. But at that point, you just go to your bank account one day or your paycheck and say, wow, there's money missing. And I really need that money right now. So that's why you don't want to ignore it until it gets to that point, because you're running out of options, and you're basically trying to negotiate some sort of payment plan with them at that point, where you don't really have any leverage. The sooner you can start negotiating with them in a lawsuit, you're going to have more leverage to kind of work out a voluntary payment plan on your terms, and something that you can actually afford. Now that is private student loans. Federal student loans are completely different. And like I said, they've changed several times over the years.
Aren't the banks losing money when they keep transferring those loans, keep selling them off? Because are they selling them for face value or more or less, or how's that work?
That's going to be depending on the market. Now, back in 2005, people were paying value for them. But 2009, some of this paper, people might have been unloading them for 10 cents on the dollar or something like that. It depends on what the market, how much interest people are, And they have very sophisticated computer programs with profiles of everybody that they're buying in their portfolio. They may be buying a portfolio of 5,000 loans, they'll have a breakdown of certain information, what they know about you, you know, what your payment history was, this and that, and they'll kind of, within that 5,000, sometimes it'll get broken down into this tier. You know, we know these people have made a certain amount of payments in the past few years, and their credit score is this. You know, this group is here, and they'll split up those loans and sell them the price depending on how they value. I mean, it's pretty sophisticated how they classify people. But to answer your question, yeah, lots of times they're dumping, but you don't know how much they paid for it on the front end. Some of these people may have bought a portfolio of loans in 2009, right after the economy crashed and all that, and then just sold them this week and double, triple the profit. You know, and you may have a situation where you were holding a portfolio of loans where only 25% of people were making payments or whatever, and now as the economy kind of turns around, more and more of them are paying. So that's, you know, that's for investors to figure out. I don't mess with that stuff, but federally subsidized loans. Now, if you go take out a federally subsidized loan right now, you would get a loan directly from the Department of Education. It will be called a direct loan. It's just going to be, Department of Education up here in Washington. They will just go directly to you on a direct loan. How it was set up when they first started federally subsidizing is you had Bank of Georgia right here. Private bank would issue you a loan. There would be a state guarantee agency with some sort of name like Georgia Guarantee Agency, blah, blah, blah. In almost every state, there would be this quote-unquote nonprofit set up that would back up these loans. And how it would be is you would take out the Families First Educational Loan Program loan with Bank of Georgia, whatever. If you defaulted, they would go to the state guarantee agency. And then the state guarantee agency would take action against you and try to collect. If they couldn't collect, they go to the Department of Education, and the Department of Education would pay off. This got to be very complicated to the point where it was originally designed to where Georgia would have an agency that backed up loans made in banks in Georgia. You started getting cross-state things where you may go to school in Tennessee and your loan, but you live in Georgia and you take out a loan and you're guaranteed by the Pennsylvania Higher Education Guarantor Association, who then sold your loan at some point perhaps to Colorado Assist or something like that. It got to be very confusing, a lot of parties in place, and it became a lot of headache to the Department of Education and a lot of administrative work for them to pay off. And so just recently, they simplified it in a much better way, in my opinion, where it's just, you have direct loans. It's just Department of Education straight to you, or it's Department of Education straight to that bank. They cut out state guarantee agencies. But these state guarantee agencies still exist because you've got 20, 30 years worth of student loans. So they're still trying to collect on this. So you took out a loan in 1984 and just recently lost your job or something like that and quit paying the bank. And again, you took it out originally with Bank of Georgia. It may have changed hands to Main Street Bank, ABC Bank, whatever. Still all the time backed up a state of Georgia guarantee agency. This is all very complicated, but it's relevant, I promise. Y'all are probably thinking this is way more boring than I signed up for. But this affects how they collect on you in federal loans. So with a federally subsidized loan, when you quit paying, they don't go through the courts. They don't have to. They have the right written in, because the Department of Education, the taxpayer over here, is putting the funds into the Department of Education to pay off these loans. They have special rights in collection. One of them is they don't have to go through a lawsuit and get a judgment against you before they can garnish you. They have the right of administrative wage garnishment. And that's what is confusing to a lot of people, is their employer will get a notice to start, you'll get a letter from a collection agency or whatever, and the Department of Education does hire out private collection agencies as well. Just like the private banks. So you may be being harassed by a collection agency, but then they send you a notice that says, this is last notice before administrative wage garnishment. That's something that you should pay definite attention to as well. And what's confusing is that sometimes if you don't know if you had a private loan or a federal loan, you may be receiving letters from all these collection agencies, and they may make these threats, this and that, about what could possibly happen to you. But when you get one from a private collection agency on behalf of the Department of Education, that's your last notice. Can be prior to administrative wage garnishment, can be from a private collection agency. So you really have to read the details of what you're getting in the mail from them, and you want to hold on to them as well if you're being contacted by collection agencies. Because federal law allows collection on a federally subsidized loan allows administrative wage garnishment, where they send you notice and then they just end up sending a garnishment notice to your employer, and they're entitled to take up to 15% of your paycheck. So you have administrative wage garnishment, and you weren't even served with a lawsuit, and you're thinking, how did this happen? Additionally, they may send you a notice right before another method of collection that they're entitled to is federal benefit offset. And that's how a lot of people will think, oh, well, I'm due a tax refund of $2,400. And then it comes, and it's all gone, because the Department of Education has intercepted your tax refund. And they will catch that. If you are due a tax refund and you owe the Department of Education money, they're going to find out. They're going to, it's not going to slip through the cracks, very rarely, but they're going to intercept that. If you were receiving any type of federal benefits, let me hold off on that. I'm not 100% certain right now, I'm blanking, about Social Security. Do you remember from last time I did this, Michael? Sorry, I'm taking a lot of Benadryl.
No. Whether they can do an intercept or a...
Intercept of Social Security. I want to say they can.
I believe they can. I believe it's...
To a certain extent, they can't take it all, I don't believe.
Right.
But I think they can do...
10% is in my mind.
They can take a percentage of your Social Security benefits. If you're receiving federal benefits, they can take an intercept for that, similar to like the wage garnishment. They can't intercept it all, like the tax refund, but they can any type of federal I think it may include veterans benefits as well. I'm pretty sure it does. So again, no action through the courts, no service of process. You got to read your mail carefully if somebody's coming after you for a defaulted student loan, and you want to make sure you know exactly what type of loan you have. Because again, if it's a private student loan and you've got the collection agency blowing up your phone and sending you letters, that's just talking. They don't really have any power. But if it's a Department of Education loan and they send you a notice that says last notice before federal offset or administrative wage garnishment, you need to take notice and try to take action. And a lot of people, the logic behind it is that taxpayers are on the hook for these loans, so they want to have a more efficient collection rather than spending taxpayer money on defaulted loans, which makes sense. But there are some issues about, and some people have brought unsuccessful federal cases about this, about due process, about receiving notice in your day in court and so on. However, you do have a separate set of rights under federal loans that you don't have under private loans. You have the right, now what's supposed to happen is you're supposed to receive a letter from the Department of Education, and this applies to guarantee agencies too. If a state agency is holding you, they have the right to administrative wage garnishment as well. You are required to get notice before that garnishment. And in that notice, it's supposed to break down certain rights you have. One of them is to request copies of your note, request copies of your records. Another is to request a hearing, an administrative hearing. So that's why people, when they bring these lawsuits about due process, the courts say, well, you do have due process, you're allowed to request a hearing. Whether you have a state guarantee agency or Department of Education affects your rights in the hearing. The Department of Education, they're all required to grant you a hearing, but you have to request an in-person hearing. You have to send a written request when you receive that notice, and if you send, say they send you a 30-day notice, say in 30 days we're going to garnish, do an administrative wage garnishment. You need to get your written request for an in-person hearing out immediately and request for your paperwork verifying your debt and servicing records immediately. Because if you send your written request as soon as you get it before the garnishment starts, they have to hold off on the garnishment pending your hearing. So they can't start that garnishment until they've actually had your hearing and made a decision. If once they start the garnishment, you still have the right to request a hearing as well. But the garnishment can stay attached to your wages pending your hearing. So if you want to get the full benefit of your hearing, get it out as soon as you get the notice, because that way you're putting a stay on the garnishment and you're able to kind of kick the can down the road and work out a deal. And working out a deal under a federal loan is a lot better because you are guaranteed the right to either you have a right to either rehabilitation or consolidation. When it's a federal loan, they must offer you some sort of repayment plan. They can't just require you pay all the lump sum. Now, if a private student loan, they get the judgment against you for, say, $20,000, there's no requirement that they take monthly payments. They can just say, you owe us $20,000 right now, we're not taking any payment plan whatsoever, you know, we're going to put a lien on your house, whatever. Federal loan, they're required to offer you a reasonable repayment plan. Now, reasonable is in the eye of the beholder, and there's no definite, I mean, they have Department of Education income guidelines and this and that. Now, what they consider reasonable may not be what you consider reasonable. But they are required to offer you some sort of repayment plan. And you can either do it through rehabilitation or consolidation. Rehabilitation is if you make 9 payments within a 10-month period, 9 on-time payments within a 10-month period, then they will basically set you up where you're back on the monthly payment plan. But they give you like this trial period plan where you got to make 9 on-time payments within that 10 months. And when you get on the new payment plan, you have the option, and this is one of the new laws that I think is good, is to do income-based repayment. Income-based is where you have the right to say, okay, well, I'm only making this much money, I can't afford to pay the $700 a month, whatever my student loan is, and they'll put you on a sliding scale. Consolidation is a similar option. You don't have to do the payment plan, but I think consolidation you can only do once. So if you previously consolidated your federal loans, you're not eligible for consolidation once you get into the situation where you've fallen. But the one point I want to hammer home is If it is a federal loan and you get that notice of administrative wage garnishment or federal benefit offset, request that hearing and, put off the garnishment, put off the intercept, and start trying to negotiate a rehabilitation or repayment plan, because they're required to go through certain steps to try to get you into a repayment plan. And that's, you have less process through the courts when you're dealing with a federal loan, but you also have more guaranteed rights about getting back on a repayment plan. As far as requesting a hearing, Department of Education only does in-person hearings at certain cities throughout the United States. Atlanta is one of them. So you would just walk right over here to the Richard B. Russell Building and have your hearing. State guarantee agencies are required to give an administrative hearing, but it is at their personal choice where the location is. I have a client who is being pursued by a guarantor agency, and we sent a written request for a hearing, and they wrote us back and said, okay, we'll meet us in 2 weeks in Horseheads, New York. I wrote it back and said, well, no, let's meet in 3 weeks in my office. So we're still fighting that battle. But the law states that, the Code of Federal Register says that a state guarantor agency may, when they give a hearing, it's at their discretion what the location is. So once you go to one of these administrative hearings, you have the right to have somebody take it down, like a court reporter, and then if you're unhappy with the decision they make, then you have the right to have a federal court review it on appeal. So you do have certain due process rights about, they can't just take your property without anybody review. But unless there's something seriously erroneous in what they're trying to collect from you. For instance, if you took out a $5,000 loan and they're telling you that you owe $85,000, you obviously want to battle that as far as you can. But if you really, if you don't have a meritorious argument about what they're claiming you owe, you can still use your right to request a hearing, request that hearing, and then while you're requesting that hearing, start asking them about filling out applications for rehabilitations or things like that, or income-based repayments. So you can get that ball rolling about, getting on a repayment plan. And the sooner you can do that, to me, income-based repayment is your best option. Now, there are a couple of scenarios where you can get your student loans completely discharged. But in large part, it is very difficult to get rid of student loans. There's no real magic bullet to getting rid of them. Now, private student loans, if people sue you and you win your lawsuit, for instance, you say, you're able to make some sort of, make some hay out of their failure to prove all their transfers about, if the loan, your promissory note, has changed hands 20 times and there's no proper chain of title that they can prove, and they can't prove their case, then you may be able to win your private student loan court case or settle it for very low pennies on the dollar. Federal student loans, in order to get a discharge for federal student loan, it's very narrow. If you started a school, say you went to ITT Tech or something like that, and you were doing a 2-year program, and you made it 3 semesters, and then the 4th semester, the school closed. So you were unable to complete your degree. That's grounds for a discharge. But you have to take affirmative steps about contacting the departments to prove up that set of facts and get it discharged. But that is grounds to get a loan discharged. If you're in a situation where a couple of cases, if you did not graduate high school and you had some school accept you into their program and sign you up for their financial aid where you didn't meet the qualifications to actually be in that school, you can possibly get a discharge. For instance, if they were falsifying your ability to get into that program and your qualifications. And the problem you have is that you had an explosion of for-profit schools. A lot of them you'll see advertised on daytime TV. And what happens is they're set up, and they're privately held schools that are owned by stockholders who are basically trying to get you to sign up for these programs and go take out federal student loans. And so they'll charge you, for instance, $20,000 a year to do an auto tech program or something like that. And then they'll try to guarantee you a certain amount of employment, this and that. And there's been some lawsuits about whether those guarantees were legitimate and whether you have rights to back against the school. But they were just, and they've had people testify, their job as counselors for these schools was just to get as many people as they could to sign up so they could get the federally subsidized loans coming in, and they're making money and their shareholders are making money, and then kids drop out. And sometimes they had situations where a kid would drop out after the first semester, but yet they were continuing to re-up student loans 2-3 more semesters after they had never taken a class. So, there are some schools like that that have done legitimately horrible behavior like that may entitle you to a discharge. However, if you received the money and you went to class and the school didn't close while you were there, you probably do not have grounds to get a discharge. If you were qualified to get into the school and you received the money and enrolled in classes, and it doesn't matter if you people contact me a lot and say, well, I went to the school and they promised me that I would get a certain job and I didn't. That doesn't meet the narrow exception for discharge. It has to be some sort of thing where they shut down or they let you in when you shouldn't have been, something that really prevented you receiving the benefit, and it was kind of a fraudulent or interfered with your education. Bankruptcy. I don't really practice bankruptcy law that much, but prior to 2005, you were able to discharge in a bankruptcy certain private loans. When they changed the bankruptcy law in 2005, the banks who issued all those private loans lobbied Congress and got them to receive the same exception or exemption as the Department of Education. The reason the Department of Education has an exemption is because taxpayers are paying for the default loan. There's no reason that private banks should have gotten that exemption in the bankruptcy code. It was just strictly big banks lobbying and getting unfair and preferential treatment. If I can go off on a rant for a second. But it's very difficult to discharge student loans. The test in bankruptcy now is basically you have to show that not only can you not afford to repay this loan right now, but that you're basically never going to be able to repay these loans. So if you may have a situation where if you become disabled since you took out the loans or something like that, you may be able to meet a certain test. I believe they call it the Brennan test for discharging student loans. But if you went through school and you're just not currently, and for instance you're 25 and you don't currently have the job that you thought you were going to have when you took out the loans, you're not going to get them discharged because they're going to say, well, you may be able to repay these in the future. And it creates a huge problem because you have there's actually more student loan debt in America right now than there is credit card debt, and none of it's really dischargeable. So it's really a drain on the economy, and I don't even think we're really seeing the main effects of it just yet. But maybe they will do things to alleviate that situation in the future. I do think they have done in the past 4 or 5 years a lot about reforming the way the banks are funded, and the way there is some new legislation about and I may misquote this, but there's a certain sunset exemption about 25 years from now. Remaining federal loan balance can be, certain portions of it can be forgiven, and I would like to see them do some more work towards that type of situation. But,
Speaking of some of those timing issues, you said you could still request that administrative hearing even if the garnishment has already started.
yes.
For how is there an end date on that? At some point, have you lost the right to request that?
I think as long as the garnishment is going on, you have a right. I'd have to double check that. But I believe, I mean, you have a right for an administrative hearing if you contest something. Lots of times, once you get the garnishment, even if you haven't requested it, the collection agency or whoever will try to get you to sign up on a rehab program where they may be garnishing $300 a month. They'll say, can you make $20 a month payment for 9 months out of the 10 to try to get the rehab program. I've heard that's because they get certain benefits for signing so many people up for rehabilitation. Go ahead.
Do you need an attorney to request that hearing, or can you do it personally on your own?
You can do it on your own, and you should receive, within your notice about the administrative wage garnishment, they should give you a detailed printout of the statute that allows you to request certain documents and request the hearing. Unfortunately, like I said, a lot of the times you will get people who say, oh, well, you want to request an in-person hearing because that puts a certain amount of pressure on them to actually do it. If you say, oh, I'll dispute this, or I want a review of my case, and they'll say, well, mail in your statement about why you think you don't know this, and they'll look at it and go, okay, denied. But if you request an actual in-person hearing, there's certain requirements where they have to have somebody who's not under the control of the Department of Education or state guarantor agency. So they have to have some sort of third-party person there in person to receive to hold your hearing. Now, again, Department of Education, you're just down here at the federal building. But if it's state guarantor agency, it can be wherever. So, they may ask you to travel to Hawaii or something like that. But, you have a right to at least by that time and kick the garnishment out and try to get on a rehab or something like that while that's going on. So,
is there an interest rate that everybody has to abide by?
interest rates, your interest rate is going to be governed by your promissory note and the contractual terms you agreed to. Now, if it's private, it's going to be probably something set out by following the index that they print in the Wall Street Journal every month, or prime plus 2 or prime plus 10 or whatever, depends on how much they charged you. Collection cost, something I meant to touch on. Private student loan. If a private bank is coming after you for a private law firm, or private loan is being pursued by you by a collection agency or law firm, and they say they're coming after you for $20,000, they are going to take, and they get a judgment for $20,000, they are going to take their cut out of what they recover. They're going to get a contingency of what they recover. Department of Education has different rules. And this is why people, lots of times on federal loans, they'll get their statement and go, wow, how did that happen? How did that, how did I get up to that amount? Department of Education allows collection costs to be tacked on top of what you owe. And the way they calculate that is not strictly, it's just really, bureaucratic formula that is based upon, say, if this collection agency was recovering 100 student loans and they only recovered on 40 people last year, they take what their expenses were last year, and rather than splitting them up amongst 100 people and having that be the fee they charge on each person, they take it amongst the 40 people. Their total costs are attributed to those 40 people they actually recovered on. So whenever you actually pay on these federal loans, you're paying the collection costs for everybody they could collect on. So you may be getting hit with these 20–25%. They've had some case law that said above 25% is unreasonable. But generally you will see around 18 or 19%, something like that, being tacked on to your federal loan. And that's you're paying the collection costs where they might have only spent 2–3 person hours on collecting on your loan, but they're putting their whole bill for everybody they're trying to collect on onto the ones that actually pay.
And that's separate from just interest.
Separate from interest. So say you took out your original two $10,000 loans in 1995, and they're collecting the 5%, 7% interest the whole time. That interest is going to accrue, and then when they go into collection, say at that point that $20,000 is up to $40,000, they're going to tack on 20% of $40,000. So that's going to be $48,000. So your original $20,000 in loans is now $48,000. And by regulations, they have that right. You can try to negotiate with them, and in dealing, if you're disputing in your hearing and things like that, you can kind of, if you request the servicing records and can go actually through them, and go through there and see some actual mathematical mistakes, which I've seen a lot of times and been able to use to our advantage. But you can kind of argue those fees down a little bit, but by law they're allowed to try to collect those fees. Did you have a question, Beck?
I had a question about, it's still dealing with loan forgiveness. But what if you work for a certain company or industry? Can you get your loans forgiven over a period of time, or if it's, okay, some job applications will say, we'll forgive your loan, or we'll reimburse you for your loans. Let's say you work for the library, for example, as a librarian, and would you have to work within a position for a certain amount of time to get those loans forgiven? Do you know?
Do you know about this at Legal Aid? Because
Yeah, well, so there's two different ways that can happen, and I won't know enough of the details probably to answer your question as well as you deserve, but there are a couple of kind of government-run programs like that I know of. One actually for, well, I don't know, people may argue whether we deserve it, but for attorneys who are just working in legal aid type industries. I believe there is a similar structure for doctors and maybe even nurses, and some of those may just be state to state kind of things. Or if you do that, and yes, they usually have a requirement that you do it for a certain number of years, then they're going to wipe out your loans. And so those are so across the board and may vary by state that you just have to look into it further. Then there are employers that offer that too, and so when you say it's kind of in the application, that may be separate. So I'm guessing if, for example, the library system had that, or an organization that I worked in before has that, they will either give you some money towards your loan or pay them. That's just something that organization is, or employer is voluntarily doing. And so, but you need to also be careful, because some of those will have a requirement that if you don't complete X amount of service. I've seen this case with nurses. They do that deal. It was kind of the deal from the beginning. If you go to this college, you get this degree, and then you work here, you won't have any loans. But if you get fired for cause, and they determine what cause is, or you don't complete that amount of time, they can come after you for not just you now being responsible for that loan, but for everything that they paid towards your loan. And I've seen some employers that will remain nameless doing that even aggressively against nurses, for example. So again, I'm not giving you enough details except, read the fine print also, because there can be a kind of blowback if you don't complete whatever terms of service.
Okay, so that makes, okay.
And some schools have certain programs
schools
like
do.
that too, so maybe run through your school.
True.
But I thought, I read that it said if you work for any type of government agency for a certain amount of time, you can petition to have your loan forgiven, especially if you work within a.
What was the last word, especially if you work?
Well, I know if you work within if you're a teacher and you work in an inner city
Police
school
office.
or
Right.
police office, but then if you work for any government agency, you can have your student loan forgiven.
I think that is part of what I was talking about with the 25-year, if there's a remaining balance at the end of how many years, it's either 20 or 25, they just wipe it.
Oh, okay.
Okay, I thought
It's
I
part of a
read
new
that.
federal program that they've done in the past couple of years.
My name is Chris Armour. I am a solo practitioner. My law firm is Armour Law LLC. I'm up around the Perimeter Mall area. Kind of one of my areas of specialization is dealing with issues of consumer debt and credit. And one thing that has started to come up an awful lot in the past few years on an increasing level is issues with student loan defaults. And so that's become kind of an area of specialty for me, is kind of helping people deal with that issue. To default on a student loan means that you have stopped making your payments on time and they are coming after you for the entire balance generally. Oftentimes they have the right, if you will look inside the documents you signed, to come after you for the entire balance once you miss a payment or have breached the terms of the contract you signed with them. But oftentimes they will be looking for you to kind of voluntarily go back on a payment plan with them. Very rarely will they not accept some sort of payment plan. Hypothetically, maybe you just graduated and you are not employed in the context that you were hoping to be, or if you're having trouble finding a job and you are no longer receiving your in-school deferment, your options would be to request a forbearance, which will kind of postpone your repayments some more. One of the downsides of that is oftentimes those type of forbearance programs will capitalize the interest that is accruing on your loan, which will mean it's going, as opposed to just paying interest on your principal will be growing every month, and therefore it's kind of like a snowball on your interest payment every month, and that will continue to happen throughout the life of your loan. But if you are unemployed, then sometimes you don't have any option other than take the forbearance, and you should take advantage of that, but you should do so with full knowledge of what you are getting into. There is a certain downside to that. If you are in a situation where you are not in forbearance and you have quit making payments or haven't been able to meet your payments, certain steps you can take affirmatively to try to get ahead of that is maybe try to contact your lenders and get on what's called an income-based repayment plan. All federally subsidized loans will have some sort of income-based repayment plan that you have the right to kind of be considered for. You may not agree with the numbers they come up with as far as your actual budget in life, but you have the right to receive that sort of program. Oftentimes private lenders will have some sort of situation like that as well, or you can negotiate some sort of program. But taking steps like that will help you get ahead of it, as opposed to starting receiving calls from collection agencies or law firms, or dealing with an administrative wage garnishment or something like that.